Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Adrana Nabilah binti Amoni. My matric number is 1212368. Today, we are from Group 4 of the MV5. We'll be presenting on the topic of crimes of passion, a comprehensive analysis of murder. Next, on this slide, this is our group. For the introduction of this topic, we bring the statistic and the example of news which is related to murder. First of all, as we know, murder is one of the most horrible crimes in this world. It has always captured people's attentions, appearing in popular social media like Facebook, Twitter, Instagram, and many more, literature, and also artistic endeavors. Murder actually has become a very significant issue in Malaysia, as we can see in the slide that statistic for murder in year 2023 show a reduction of 292 cases, equal to 1.1% compared to the previous year. However, it does not mean murder cases are not serious crimes. We also bring the recent heartbreaking news of murder cases on a child named Zain Ryan in Malaysia. In this case, the identity of his killer remains unknown until today. Now, we will move to see what provisions are related to the murder topic. The first one is section 300 of the Penal Code, where in that section, it defines the meaning of the murder and also the circumstances that fall within the meaning of murder. Plus, the exception for the murder case also have been governed in section 300 of the Penal Code. The second one is the section 302 of the Penal Code, where in this section, it provides us with the punishment if someone commits the murder offence. And lastly, section 34 of the Penal Code, which is relates to the joint liability of the wrongdoer or the murder.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Aisyah binti Muhammad Nur Arif and my matric number 1212366. Now, let's talk about the exception of murder under Malaysian Penal Code. Ladies and gentlemen, section 300 of the Penal Code has provided the guideline of murder. However, it also constitutes the exception of murder, and this must be read together with section 299 of the Penal Code, where this provision has clearly stated about the culpable homicide. Section 299 of the Penal Code has said, one who doing an act with the intention of causing death or bodily injury as likely to cause death, or who with the knowledge that he is likely by such act to cause death commits the offence of culpable homicide. Besides, the exception 1 under section 300 of the Penal Code states that the culpable homicide is not murder if the offender deprived of the power of self-control by grave and sudden provocation causes the death of the person who gave the provocation or causes the death of any other person by mistake or accident. In addition, exception 2 under the same provision provides, it does not amount to murder but culpable homicide if the offender exercises the act with an intention of good faith of the right of private defense of person or property where the person exceeds the power given to him by the regulation of law. Either sufficient or likely to cause death of a person in order to determine whether the act of the offender liable under section 299 or 300, and the court here need to determine whether there are provocation which was grave and sudden enough to prevent the offence from amounting to murder, or the offender act is actually exercising by the intention of good faith and therefore fall under culpable homicide instead of murder. In the case of public prosecutor and Stephen Lani, the court held that the respondent's act fell squarely within the section 299 of the Penal Code and fell short of section 300 of the Penal Code. And in this case, the act of respondent was considered to have an intention to cause death by causing bodily injury. However, the court also has a look at the fact that the respondent had no medical knowledge and that stabbing the underneath armpit would cause major blood vessel to be severed. Therefore, both provisions have been successfully liable by the respondent. Besides, in the famous case of Regina and Ahluwalia, the respondent had bulk caustic soda and petrol and put some of the petrol into a bucket before throwing the burning stick into the bedroom where the deceased was asleep. The deceased died a few days later from resultant severe burns, and the respondent appealed against her murder conviction. In the Court of Appeal, despite the delay after the last provocative act or words by the deceased, the court refers to the slow burn reaction which often derive from the harmful act received by the wife, which means the woman is subject to persistent ill treatment, may immediately lose self-control.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is MVRD3R, matrix number 1212362. Okay, so today I would like to present on the element of murder. So for murder, there are 5 elements in it, which are mens rea, actus reus, concurrence, causation, and harm. So all of these elements must be presented by the prosecutor to classify the case as a murder case. If one element is missing, the case cannot be tried as murder, but may be tried as other cases like manslaughter or culpable homicide. So the first element is mens rea. So for mens rea, it widely known as the intention of the perpetrator, the perpetrator's guilty mind. So the intent that constitutes malice is varies. There is the intention to kill, which signifies that the perpetrator purposely wanted to kill the victim. He or she planned the victim already to kill the victim. Second, there is the intent to cause bodily harm that would result in death. And thirdly, there are also reckless indifference to human life. I'll give you an example, which is there is a girl who decide to kill a person to explain what it feels like. So she then drives her car slowly to a crosswalk and runs down to a boy who is crossing the road. So she is acting with the intent to kill her victim, which would be referred as intentional malice. Next is actus reus. Actus reus is defined as physical act, omission, or wrongful act that constitute the crime, which in the case is the act of the accused that caused the victim death. For example, actus reus occurs when one person deliberately or intentionally shoot another person with the intention of murdering that person, and he succeeds. Next is concurrence. Concurrence implies simultaneously or contemporaneity. So concurrence occurs when there are 2 other elements presented, which is mens rea and actus reus. So to clarify, there is a coexistence of criminal intent and also criminal act, and both of it must occur at the same or essentially simultaneous moment. So for concurrence, the prosecution must prove that the defendant's criminal action or omission was motivated by his guilty mind. Next is causation, the 4th element. The causation refers to the defendant, the relationship between the perpetrator conduct and the consequence of his conduct, which is harms. So the prosecution must prove beyond a reasonable doubt that the defendant's act resulted in the crime or of harm or injury. So to establish this element, the prosecution must prove that the perpetrator action caused the death of the victim, and it can be proved with like a medical proof or expert. The last element is harm, means that the act or intent must be the causes of the actual harm. So harm in a murder case means there are the death of the victim. So the prosecution must prove that the death of the person was the result of the perpetrator's conduct or action. That's all for the element.
Assalamualaikum warahmatullahi wabarakatuh. My name is Ahmad Farid Irfan bin Aminuddin. My matric number is 1212367. Now, I shall continue to present regarding to the punishment for murder under the Penal Code. Therefore, I provide here 2 sections, which are section 302 and section 304 of the Penal Code. These 2 sections are likely related to our discussion topic, which is murder. Let's moving forward to the first section, which is section 302 of the Penal Code. This section states that the penalties for murder are severe, with possible sentences ranging from the life imprisonment to the death penalty. Death penalty is guaranteed for someone who is intended to commit murder. This scenario should be highlighted that the law in our country do take murder as a serious crime, as it is directly mentioned that someone who commit murder shall be punished with death. Let's think why Section 304 of the Penal Code is important in our discussion. It is clearly states that the punishment under this section is lighter than Section 302. Is it possible for a killer or murderer to get a lighter punishment instead of death penalty? It is simple. Section 302 outlines the punishment for the murderer. However, Section 304 of the Penal Code outlines the punishment for the manslaughter. The word manslaughter is not actually used in the Malaysian legal system. Instead, we call it as culpable homicide not amounting to murder. The punishment for culpable homicide not amounting to the murder that's stated under Section 304 is that you can be jailed up to 30 years with a possible fine if you intended to cause death or cause injury that would likely lead to
Okay, so now I will proceed on the case. I will present on the case of Mahathir bin Yusof and another against public prosecutor. So this case is an appeal case where the accused, there are two accused, is trying to put their case in a private defense. So this case involved with two appellant and the witness. So both of the appellant sought the assistance of a witness to recover money owed by the deceased to the appellant. So all of them, the appellant, both of the appellant and the witness, are supposed to meet the deceased under the pretext of recovering stolen television sets. So according to the witness testimony, the second appellant hit the deceased's head with a wooden baseball bat, and the first appellant assaulted the deceased with a machete, which is the parang. So this incident occurred like 5 to 6 times, resulting in severe head injuries to the deceased and resulting in the deaths of the victims. So they are trying to defend their action. In their defense, the appellant, both of them contended that the deceased the first one to attack the witness with the baseball bat and causing a conflict between them. So they argued that during the conflict, during the fight, the first appellant just simply observed and did not do anything, did not participate in the fight between them, and they claim that the deceased assaulted the second appellant with the parang, and somehow the appellant managed to avoid it. So the appellant claims that they only hit the deceased twice with the bat, and however, the weapon that they used, like the baseball bat and the parang, the machete, are disposed in the river. So there is no evidence in this case for the deadly weapon, for the instrument that they used to kill. So in this case, the appellant were charged with Section 302 coupled with Section 34 of the Penal Code. And at the trial, the judge has already rejected the appellant's claim of self-defense and their claim also on the grave and sudden provocation by the deceased. Hence, it is because the requirement under Section 300, Section C of the Penal Code, were actually proven when the court found that both of the appellant has intentionally caused fatal injury, which is assaulted with parang and also hit with the baseball bat. They have the intention to cause a fatal injuries to the deceased. So their claims for private defense was rejected by the court because the injuries sustained by the deceased have been proved they were inflicted numerous times by the full force assault from the appellants, both of them. Like, because of like it occurs like 5 to 6 times by the appellant, it indicates that the appellant went beyond what is permitted under private defense. Because in private defense, we can only like defend ourselves, but not to extend to kill that person. Yeah. Therefore, in this case, the appellant, both of them failed to establish a right to private defense under Section 2 of Section 300 of the Penal Code. That's all from me for the first case.
For the next case, I provide to you the case of Mickelson Gerald Wayne against the public prosecutor. The appellant was initially convicted and sentenced to the death for the murder of his ex-wife. The appellant, however, claimed that he acted in self-defense, while the prosecution contended that the appellant had the intention to cause the specific injury that led to the deceased's death. The courts below initially found in favor of the prosecution, leading to the appellant's conviction for murder under Section 302 of the Penal Code. Furthermore, the appellate court considered the circumstances surrounding the deceased's death, including the nature of the injuries, the presence of the provocation, and the absence of premeditation. Based on these considerations, the appellate court allowed the appeal, quashed the murder conviction and sentence, and instead convicted the accused of culpable homicide not amounting to murder under the Section 304B of the Penal Code. Then, the accused was sentenced to the 7 years imprisonment.
Okay, the next case is a case that emphasizes Section 300 and Section 302 of the Penal Code. It is the case of Zulkifli bin Muhammad and public prosecutor, where in that case, it had been decided at the federal court level in Putrajaya. In that case, the appellant had been charged because of murdering 75-year-old woman, which this falls under Section 300C of the Penal Code. The appellant admitted that he had hit the deceased on the head twice with a baseball bat, which caused blunt traumas that lead to her death. Even he claimed he did not have any intention for the act. The court held that the appellant's defense was rejected and the appellant's act falls within the meaning of Section 300 of the Penal Code. The appellant was therefore liable and found guilty, which sentenced to death under Section 302 of the Penal Code.
In conclusion, it is critical to address the topic of murder with sensitivity and awareness of its serious offence. Discussion about murder entail broader issues of violence and mental health. Furthermore, it is to prevent causing harm to the victim's family or society, as well as to avoid promoting harm that may glorify violence. As we all know, there are a lot of new cases relating to the murder. Hence, boosting public awareness within society is essential to tackling the social, economic, and psychological factors that contribute to the violent conduct. With that, I guess our presentation is complete and I shall close our presentation. Thank you.